Hi, I'm Nicole Denmon. I'm a partner here at Denmon Perlman, and I am the lead attorney for the Estates and Probate Division. I want to talk to you today about a few essential estate planning documents that I think everyone should have, and a couple other optional estate planning documents as well. The first document that I think that everyone should have, and perhaps the most important document, is called a Designation of Healthcare Surrogate document. With this particular document, it allows another individual, your surrogate, to step in and make decisions on your behalf if you can't or you don't want to. For example, perhaps you've been involved in a car accident and you're going to be okay, but you're down and out and you're hospitalized and you cannot make healthcare decisions for yourself. This would allow somebody else to step in and make those decisions for you. Another example would be that you've been diagnosed with an illness or a disease and you've been given several options by various doctors. You don't want to make those decisions because you feel as if you're not in the right state of mind to do so. You could allow your healthcare surrogate to step in and make those decisions for you. This particular document is perhaps the most important document that you will create and agree to, because what do we have that's most important? Our health. Another very important estate planning document that I think everyone should have is called a living will. A living will allows you to make the decision ahead of time as to when you want life-sustaining procedures to be kept up. For example, if you've been involved in a very serious accident and you're being kept on life support and there's no reasonable certainty, and many doctors agree that you will not come back and be your normal self and you're brain dead, it allows your family members to make the decision for you to not continue those life-sustaining procedures or measures. It's a very important document, and most people do choose to allow family members to make that decision for them once they've consulted with doctors. Another estate planning document that I generally recommend for my clients is called a durable power of attorney. This one doesn't deal with health, but instead it deals with your finances. It allows someone of your choosing to step in on your behalf and make financial decisions for you. In other words, they would be allowed to go to the bank to manage affairs, sell real estate, and etc. Many people choose this document to have this document for their spouse because it's very convenient, or their significant other, or someone else that they trust that could step in and manage their affairs if something occurs, which would make that necessary, or if they're away for very long periods of time. The important thing to remember about this document is that it is a very powerful document, and it does give someone else access to your financial documents and affairs. Once they have this document in hand, in fact, they can go and they can do whatever they want to with your finances, so keep that in mind. It's very powerful and should only be given to someone who you trust greatly. Another essential estate planning document is a last will and testament. Most people know what that is, they just don't understand the specifics of what should be included in a last will and testament. One of the most important things to include in a last will and testament is a guardianship provision as to what will occur with your children if they are under the age of 18 if something were to happen to you and or your spouse. Another thing that's designated in the last will and testament is to what happens to your assets if you were to pass away. Who will they go to? How will they be dispersed? A third thing that's included in there is your funeral arrangements. What will happen? Do you have specifics that you want to be included in there as to how you want your funeral to occur or how it will be paid for? All these things are very important. As you manage your affairs, you'll realize that there are lots of things such as your house, your contents of your house, your stocks, bonds, mutual funds, and other things that need to be addressed in a last will and testament to make sure that what you want to happen when you pass away really does occur. Another essential estate planning document is a revocable living trust. Now, many people come to me and tell me that they want a revocable living trust and not a last will and testament. One of the reasons they say is because they want to avoid probate. But no matter what, if you have a revocable living trust, you'll always have a last will and testament too. A last will and testament will deal with some minor things or some other things that wouldn't be dealt with in a revocable living trust, such as what will happen to your minor children if something were to happen to you? Who will become the guardian of them? or some simple funeral instructions? What will happen with some of your tangible assets? Those things could all be addressed in a last will and testament. All other assets would be poured over into the revocable living trust so that we could distribute them according to your wishes. Now, what is a revocable living trust? A revocable living trust, think of it this way, is just kind of like a big pot. And whatever assets are titled in the name of the trust, or that you actually write into your trust, such as bank accounts or your home or different stocks, bonds, mutual funds, things of that nature, any assets are then in fact in the trust. They fund the trust. Now, you outlined in your trust document how you want your assets to be distributed and who you want those assets to go to. Now, the great thing about a trust, well, there's many great things, but a couple of them are, if you want to continue to decide where your money goes and what happens to it, even after you pass, you can do that. Perhaps you have a son or a daughter or a family member that you'd love to give $50,000 to or $100,000. But you know if you gave it to them that day in a lump sum, it would be gone the very next day. Well, with a revocable trust, you can actually spread out your distributions, and your trust can continue to live on even after you pass away. Another great thing about a revocable living trust, and perhaps the best benefit, is that you don't have to go through probate like you would with a last will and testament. A probate can be very costly, but most of all, very lengthy. The average probate in the state of Florida takes 18 months, whereas a trust administration requires no court intervention unless there's an issue, of course, and usually is done in a couple of months. It allows your trustee, the person who you appoint to step in and work with your lawyer, and your financial planner, if you have one, to work together to make sure that all your assets are distributed exactly how you want them to be distributed. One tool that I use when drafting estate planning documents is called a special needs trust. This trust comes into play when you have a family member that needs something set up for them so that they don't get rid of benefits that they may have, or that they're not entitled to them anymore if they come into a certain sum of money. For example, you may have a family member that's disabled or has some sort of disability that you may not even think of, but they get financial support for that disability, perhaps from the government, or are entitled to certain group benefits or things of that nature. Autism is one that comes into mind. With a special needs trust, you basically set up a scenario where there is a third party, your trustee, that someone that you trust that you've appointed, or your attorney, who you can also appoint as the trustee, or perhaps a financial planner, that makes sure that this person who you need to fund but can't give money directly to is in receipt of those funds. For example, your trustee would be writing checks to third parties for anything: medical expenses, college, schooling, hobbies like sailing or art or ballet or anything of that nature. The key is to make sure that all of their expenses and their needs are taken care of, but to make sure that they never actually directly get any of the funds. This will ensure that they get to keep any and all of the benefits that they receive and that they still are entitled to them. Another important estate planning tool or document that I draft, generally for my clients who are later on in life, is called a designation of pregnant guardian. A designation of pregnant guardian allows you to designate who's going to step in and take care of you as far as your health, your medical decisions, and you as a person, any decisions that need to be made, and your finances as well. This allows you to say, I want a particular person to have the power if something were to happen to me and I can't make my decisions anymore, perhaps because you have dementia, or you've been involved in a really bad accident later on in life, or something of that nature, or you're just too elderly and you can't make those decisions anymore. It allows that person to step in and become your guardian per se. This document is generally drafted and filed with the court. The court then usually appoints the guardian of your preference that's listed within that document. Another document that I sometimes draft for my clients, but is requested far less often, is called an irrevocable trust. The reason that I don't draft this document as often is it is an asset protecting device. However, the issue is you have to be really certain as to what you want to happen with your assets, because you can't change it like you would be able to a revocable trust or a last will and testament. With a revocable trust or a last will and testament, you can change it as many times as you want, make as many amendment codicils, revoke it, take it away, make a new one, do whatever you want with it. But with an irrevocable trust, the standards to change it are very, very strict. For example, if you made changes, they could be changes in beneficiaries and things of that nature, but the current beneficiaries that you have listed would have to agree, and so would your trustee. An irrevocable trust, again, is a certain tool that many people use in order to protect assets and to create a trust document to decide where their assets will go if they pass away. However, it is not a document that is used frequently. Now that you've heard about all of these essential estate planning documents and tools, and even some optional ones, we'd like to give you even more information about this and the other practice areas at Denmon Perlman. If you just click below to subscribe to our YouTube channel, you can get lots of more information about various practice areas.